welcome again to everyone who is joining us for this timely and important topic on landlord-tenant evictions and mediation. I want to first give a shout out to our sponsors who are helping to make this possible. Along with the Alabama Center for Dispute Resolution, we have the dispute resolution section of the Alabama State Bar. We have Volunteer Lawyers Birmingham and Legal Services Alabama. So thank you all for helping to promote this webinar. I also want to recognize our panelists and presenters on this topic. We've got 2 hours to cover, and the first hour is going to be presented by Holly Ray Kirby. Holly Ray is the managing attorney for the Huntsville Office of Legal Services Alabama. Holly specializes in housing law and homelessness prevention with a focus on defending evictions, preventing foreclosures, and using bankruptcy as a tool to help maintain housing stability. Holly skipped high school and began college at the age of 14 at Mary Baldwin College in Staunton, Virginia. She earned her Bachelor of Science degree in Healthcare Administration from Auburn University in 2003 and her Juris Doctor from Faulkner University's Thomas Good Jones School of Law in 2007. Her work allows thousands of families to remain in their homes and to avoid the lifelong detrimental effects of homelessness. Now, Holly's just our kickoff speaker, and she's got a lot to cover in the next hour. After Holly's presentation, I will introduce our panelists who are attorneys and mediators who are going to talk a lot about and answer questions about the mediation process and how mediation can be a good tool to help both landlords and tenants. So Holly, I'm going to go ahead and turn it over to you.
Thanks, Eileen. Can everybody hear me?
Thumbs up.
Awesome. So Eileen read you my bio. My name's Holly Ray. I manage the Huntsville Office of Legal Services Alabama. I have been at Legal Services for 17 years. I've been here as a law student, then a fellow, and then a staff attorney. Now I'm managing attorney since I was a first-year law student. This is the only job in the law I've ever had, only job I ever wanted, hopefully the only job I ever will have. And, you know, through a long career at Legal Services at this point, or at least a moderate career at Legal Services, I've learned a lot about what really matters to families living in poverty in Alabama and working poor families. And one of the things that I think surprises people is that what matters to families in crisis or low-income families is the same thing that matters to all of us. Having a safe place to call home, having that base is the beginning of everything. Everything starts at home. And when we talk about evictions, you know, we handle them in the district courts in Alabama. I'm going to walk you through the roadmap. They move fast. And I think what kind of gets lost in that shuffle and what I want to impress upon people is how lifelong detrimental effects from eviction can affect families. We know that a child that is evicted at any point during their elementary school years is 20% less likely to graduate from high school. That's not a small statistic. That's not, you know, a district court case level statistic that we like to think about. We also know that when we talk about housing stability, we're talking about generational wealth. We're talking about the ability to build a base for eventual home ownership. Eviction sets families way, way back on that path. We also know that eviction often leads to the loss of the vast majority of their personal belongings. You know, when we think about, I wouldn't say celebrated, but we just acknowledged the 10-year anniversary of the 2011 tornadoes.
So like when I adjust it up and down, it'll.
You know, losing every stick of furniture you own, losing your kid's Barbie dream house. Those things are not small effects. And so that's kind of where I start my look at eviction. None of that is my own invention. A lot of this comes out of a gentleman named Matthew Desmond. He is a professor at Princeton University. He wrote a book called Evicted. He won a MacArthur Genius Grant for his work in studying the sociological and psychological long-term effects of evictions on families. So all of that to say that when we go through this roadmap, when we look at how this happens, bear in mind that this, very much like a divorce almost, is a lifelong decision for families that has lifelong repercussions that we want to work our way through, that we certainly want to have into consideration when we're looking at how we feel about evictions. So we're going to start with our eviction roadmap. This is how evictions work in the state of Alabama. I'm going to say with the caveat, eviction law in Alabama hadn't changed very much since 2006. If you practiced before that, we were under the Sanderson Act. We have been under the Uniform Residential Landlord-Tenant Act for about 15 years. And up until COVID hit, it had very few substantive changes that had been tweaked over time. But we very much knew how to predict what would happen in an eviction for the most part as it made its way through the court system. So I'm going to start with giving you the prior to March 2020 version of what to expect in these, and then I'm going to explain some of the COVID tweaks. I say that an eviction starts when life happens. Something happens that causes your tenant to breach their lease in some way. The most common way that this occurs, as you might imagine, is non-payment of rent. But we also see evictions for things like an unauthorized tenant. They've moved a friend or family member in that shouldn't be living with them. We've seen people use their apartment as an Airbnb. That's a breach in just about every lease in Alabama. We see it with unauthorized pets. Can't have Fluffy if the rules don't allow Fluffy. And increasingly, we're seeing it with housekeeping violations. With some of the COVID things that we'll go into, we're seeing landlords navigate away from non-payment evictions that they may not be able to file and filing them for other reasons. Housekeeping has become a perennial problem during COVID, and that's something that we see. But life happens, the lease is breached. The first step in the eviction process, and it truly is key, is the notice to cure or quit. For just about everything that a tenant could do to breach their lease, you've got to give them the chance to make it right. If it's non-payment of rent, you've got to give them the right to pay it and make things right and stop the eviction. If they've brought in an illegal tenant, they have to boot that tenant out. If they've brought in an illegal pet, they have to find Fluffy a new home. If it's housekeeping violations, they've got to clean things up. For just about all of these things in Alabama, it's a 7 calendar day notice to cure or quit. Gives you a chance to make things right. One of the most common things that we see is that the notice doesn't contain that right to cure. A lot of times we'll see notices that provide an inflated amount of money damages to bring the rent current. We'll see notices that don't give the right to cure for things like the illegal pet. And that can be key. Maybe that pet isn't a pet at all, it's a service animal. We'll also see it denying right to cure for what they perceive as a dangerous condition. There are only a handful of areas where you can't, you don't have to offer the right to cure, and they're exactly what you would probably common sense think they would be. If your tenant has committed a drug-related crime on the property, if they are in possession of illegal drugs on the property, if they have fired a gun on the property. I got one last summer where someone maybe drunk drove their car into the swimming pool on July 4th weekend. Those kinds of illegal activities are not curable offenses. But for the most part, 99% of what you see is going to be non-payment of rent or something in those lines. And the tenant has to be given the chance to make it right. They also only have to be given the chance.
Hi, it's Eileen. I wanted to let you know, right now I'm only viewing your main title slide. I don't know if you've progressed on your slides.
I did. Let's hope that. Does this show you the next one?
No, ma'am. I'm seeing your PowerPoint, what appears maybe to be in the view mode, where on the left side are your slides and then your title. I don't know if it's in the slideshow mode.
Let's see, it should be.
And right now, we're just getting a few comments back about seeing a blank screen or can no longer see your slides.
Okay.
So if you'd like, I have your PowerPoint. I can pull it up.
That would be wonderful because I'm not sure what it's doing. This is how I've always done these. So please pull it up. I'm on the second slide. Looks like a roadmap.
Ladies and gentlemen,
I'm so sorry.
That's okay, ladies and gentlemen. Sometimes, technical things come up during the presentations, and we're all, like I said, among friends and flexible. So we're going to just take a moment and regroup. If you'll just bear with us for a second.
And I see a comment that says 7 days. It is 7 calendar days. It is not 7 business days. While Eileen is fixing the PowerPoint, there are a few exceptions to the landlord-tenant law that are important to know. There's also one glaring inclusion that folks need to know. If your housing is basically a secondary condition to something else that you receive. So if you're—
I'm sorry, I really hate to interrupt. Can you stop sharing your screen?
Yes, I can.
Okay.
There we go. Okay, much better. Okay. There are a couple of glaring exceptions to the rule that people need to know. Things like a dormitory, a fraternity or sorority house where you're living is secondary to receiving an education. Those are exceptions to the Landlord-Tenant Act. Anytime you're receiving health care, so that can be anything from an assisted living facility to a nursing home to a hospital, to an inpatient rehab facility for alcohol or drug rehab. Those are all exceptions to the Landlord-Tenant Act. They don't follow this timeline. Long-term hotels, in some but not all cases, don't follow this timeline. If it is your exclusive residence and they rent it to you knowing that it's your exclusive residence, even though it's an extended stay hotel, it's still going to follow this timeline. They can't, switch the key cards out like a traditional Holiday Inn when you didn't pay for the second night could. One glaring inclusion to this law are mobile homes. Tenants who rent a mobile home to live in, or who rent a lot on which they place a mobile home that they own, are included in this act. That to me is a glaring problem, because in most cases, moving a mobile home in the state of Alabama is going to take more than 7 days, and it's going to cost a significant amount of money that most tenants don't have immediate access to. I will also give a shout out to my least favorite thing in the world. I hate rent to owns, bonds for title, whatever you want to call them. I am well known for my hatred of them because they're all very contract specific, and in most cases the contract's like written on a cocktail napkin. Some rent to owns may fall under this act. I generally argue that they don't, that they are ejectments, which would be something like a post foreclosure eviction for those who are not familiar. Are my slides back up now? I think Eileen's got them up.
Can you see the Alabama eviction roadmap?
I can.
Great.
I can see it, so if everybody else can see it. Okay, I see.
I hope so. And just let me know when to go to the next slide, Holly. And thank you for your patience.
So we're on the second step of this roadmap with the notice to cure or quit. Again, the notice is key. Where we at Legal Services win evictions, where we are able to get them dismissed and set aside, probably about 80% of the time, it comes out of the notice itself, the step that happens before you ever enter the courtroom. And in a lot of cases, the step that the landlord takes on their own without legal counsel. I see a comment that says, how, where, and to whom do you serve the 7-day notice? It is placed on the front door. It's called nail and mail. It's going to be placed on the front door of the rental residence. It's also going to be sent in regular US mail to the residents. The 7 days start at the moment that you tack it up on the front door. It is given to the tenant in that way. And again, depending on the terms of the lease is the when that you provide it. Most of the leases that I see are due on the 1st, in default after the 5th. So this notice could be placed as soon as the 6th of the month, but that's specific to what their lease says. If this notice fails in some way, the case hasn't met a condition precedent to filing and should be dismissed when it enters the court. The next step that you'll see is the eviction filing. That is where the landlord or their counsel take a case to the district court of the county where the property is located. The tenant will be served with those court papers. And again, nail and mail is sufficient for a suit for possession in Alabama. That means, once again, all you've got to do is post it on the front door, and all you've got to do is drop a copy in the regular US mail. That is sufficient for possession. You can also sue for money damages for things like unpaid rent in an eviction. In that case, you've got to have personal services on the money damages, same as with any other court case. Once this tenant is served, one of the shortest deadlines in civil court in Alabama kicks in. They have 7 calendar days to file an answer. Our clerks will have that answer form. There is a generic form that most of the clerks give out that has some check boxes for things like, I deny that I owe anything. This wasn't served on a member of my household. I admit that I know some, but not all. And the tenant has the opportunity to file that answer. But what we try to impress upon people is how very, very short that deadline is. 7 days is not a lot of time to either get yourself to the courthouse and file an answer or find a lawyer that tells you how to file an answer. And a lot of people just plain don't answer and lose by default because the deadline is so very short. Evictions in the Alabama Rules of Civil Procedure are given expedited filing rules. An eviction is literally supposed to leapfrog any other district court hearing. And because of that, the court dates on these are generally set really, really quickly. It's a minimum of 14 days. And in most cases, we're seeing them take 14 to 21 days to get set. In most counties in Alabama during COVID, that was still true. Once the governor's eviction moratorium lifted, we were seeing those filed and set in court within about 2 to 3 weeks of filing for the most part. Evictions just kept rolling through the whole thing. And I think that is kind of in controversy with public perception of, you see all of these moratoriums on the news, and we'll get into those in a second, but you think, oh, nobody's getting evicted right now. It's the exact freaking opposite. It's a tidal wave of them. In court, I tell clients that we're looking really outside of these COVID factors that we'll get into. Pre-COVID, we were looking at 2 factors. Did you breach the lease or did you not? Did your landlord file the right kind of notice or did they not? If all those I's are dotted and T's are crossed, there's really not a lot that I can do to prevent a judge from evicting you. And we switch paths towards looking for, is there any way to reconcile this? Is there a way to make a payment plan with the landlord for what you owe? Is there a way to negotiate time so that you can move with dignity and without the involvement of the county sheriff? Those are what we start looking at. And those are really where there's room for mediation in evictions on things like time to move with dignity or things like making a payment plan. For a lot of our clients, really one bad turn is what got them into an eviction in the first place. And COVID has, regardless of your income level, given a lot of people bad turns lately. After the court case is over, if either side disagrees with the result, they have 7 calendar days after the order is issued to move to vacate that order, or they may appeal it to circuit court. Obviously, it's an appeal from district to circuit. It is a trial de novo. We start all over. These are supposed to carry the same expedited filing rules in the circuit courts. As you can imagine, in normal times, that usually meant a 2 to 3 month wait in most of our circuits. That has dramatically changed with COVID, and we are seeing them take some judges hearing them as an emergency docket because they can't hear anything else. Some of them are taking them in the order of everything else they've received, and we're getting eviction appeals set 7 months out. That's kind of been the wild, wild west. If you don't appeal the case and the order becomes final, a writ of possession will be granted. That is, I tell clients to think of it like a civil warrant. It's what authorizes the sheriff to come out and keep the peace while you and your belongings are removed from the property. In most counties, that set out is scheduled by the landlord in conjunction with the sheriff, who is there to watch and keep the peace while things are removed. In most counties in Alabama, because these are, I've had sheriff's deputies tell me they're about as dangerous as a domestic call, they will not release the date. So we don't know when you're going to be kicked out. Once that writ of possession is in the wild, you've got to assume that it can be at any minute. Some of our judges handle these. If we have someone who is in frail health in Madison County where I practice, the sheriff says basically, if they're on hospice, you really need to call me, so I've got an ambulance waiting. But contrary to public perception, having young children in the house, being an expectant mother, being in poor health does not stop the set out in the same way that it wouldn't stop an arrest if you had committed a crime. And that's really a hard thing for people to understand. that, you know, they assume that these human factors will stop them from being evicted, and they absolutely do not. The court, Lady Justice is blind. She can't consider that. I'm going to answer a few questions before we go to the next slide. I think I answered how, where, and to whom do you serve the 7th day notice. If it is a month-to-month tenancy, generally you're giving that 30-day notice to terminate the tenancy, and if they aren't out on day 31, you're filing an eviction based off the end of the tenancy. That's also true of the end of a 12-month lease or any other lease. You would be evicting at that point based off termination of the lease. In Alabama, if a tenant remains in that property past the end of their lease, you could actually sue for treble damages as a holdover tenant. We don't see a lot of that, but it is their right. Are there any jurisdictional exceptions to where the action is heard in a commercial lease? Most of the time I've seen that handled. We don't do a lot of commercial lease issues at Legal Services for obvious reasons. But a lot of the times we see that handled in the contract. Otherwise, it would still be where the physical property is located. On an appeal from district court to circuit court, does the tenant have to pay the past due rent, the amount of the judgment for unpaid rent? No. So if you are a tenant appealing from district to circuit, as I've mentioned, that can take months. We don't want people living rent-free and basically abusing the court system to keep a free roof over their head. So when a tenant appeals from district to circuit court, there is a bond due. That bond is the amount of rent that has come due between the filing of the eviction in district court and the filing of the circuit court case. So if your eviction was filed on March 15th and we're now filing your appeal on May the 4th, April and May's rent are due as bond. Additionally, that rent as a general rule is going to be due as it would be due under the contract, paid in escrow to the clerk of court every month. So in the example I just gave, if that case is set for trial in August, June and July's rent are going to be paid into the circuit clerk of court. And if they're not paid in time, that can lead to the filing of a writ of possession during the appeal. There are cases where the amount of rent actually due is an issue in and of itself, where it's not just look at the lease and the lease says $800 a month. We get some cases with diminished value. That can come from where there's damage to the property, either through improper maintenance or through a natural disaster. That can lead to the court having to make a ruling about what the rent due actually is. We also get quite a bit of these with tenants who live in housing that has some kind of subsidy on it, whether they're in public housing or have something like a Section 8 voucher. The tenant's portion of that rent is a moving target based off their income. And depending on the reason for eviction, that subsidy may have stopped. In that case, again, your judge is going to have to make the determination of the rent due. And I think that answered the last question, which was how the amount of the bond is calculated. Eileen, if we can go to the next slide. So again, notice is key. The reason for the eviction has to be stated really clearly in that notice. In almost all cases, unless they are doing something that puts their fellow tenants at danger or puts the property at grave danger, has to give that right to cure. A couple of the sticking points that we see in evictions commonly are, again, that denial of right to cure. I can't emphasize it enough. It is shocking how often it gets left out. And also some of the issues with filing. Some cases will have a condition precedent to filing. One of those may be the ownership of the property. The person who sues matters. If you are an LLC, if you are a corporation, if you are a PC filing in the state of Alabama, this is district court. You are a legal entity. You cannot represent yourself pro se. You have to have counsel. So, you know, Arbor Acres PC or Arbor Acres LLC, hopefully they're not a PC, can't file with the property manager filing the complaint. They have to hire counsel to proceed. That is a shockingly common issue for folks who are just not well versed in the law. We also, again, get issues with subsidy protections. In some cases, if your tenant is on something like a Section 8 voucher, they may, or if your property is a low-income housing tax credit property, some of our senior housing properties where rent is income-based. All of those are going to have their own special protections that are a condition precedent to eviction. In almost all cases, those tenants are going to be entitled to a grievance hearing to explain the reason for eviction and try to make things right. In most subsidized properties, you also don't have, in a standard landlord-tenant lease, at the end of my 12-month term or whatever my term is, I can break the lease for any reason, give the notice stated in the lease, a 30-day or 60-day notice, and I'm out. The same is true of the landlord. They can non-renew me, and they don't have to give any reason at all as to why they've chosen not to rent to me anymore, so long as the time complies with the lease. That's not true on most of your subsidized properties. You're going to have good cause for terminating the lease. This particular sticking point has gotten very interesting as our real estate markets in some areas of the state, like where I am in Huntsville, have started to blow up. A lot of our affordable housing has started to non-renew tenants so that once they've got all of the tenants out, they can bulldoze or remodel or gentrify in some way. And those tenants, in many cases, if they're paying market rent, if there is no subsidy, there is no defense. And that in and of itself is creating a crisis where these folks are getting an eviction filed against them simply because they have nowhere else to go and their lease is not renewed. All of this matters because as an attorney, what would you advise your clients when they are seeking prospective tenants? You're looking for evictions on their record. The minute someone has an eviction filing on their record, things get really hairy on finding their next place to live. And so everything that I have just told you is landlord-tenant law prior to March 2020. And again, it's been the law of the land for about 15 years, since 2006. That's kind of where we're at. I didn't touch on a few issues like repair issues and how they fall into this. The reason I didn't is that unless your failure to repair makes the property completely uninhabitable or in large part uninhabitable, it doesn't matter. Our Landlord-Tenant Act says that paying rent is a prerequisite to getting any of the remedies for poor repair issues. That's another problem that we get often in public perception is I shouldn't have had to pay my rent. I was covered in rats and roaches. That really sucks. No one deserves to live that way, but it also doesn't stop your landlord's right to evict you for non-payment of rent. Eileen, if we can go to the next slide.
And Holly, hopefully you can see the eviction moratoriums during COVID-19.
Yep.
Great.
So then we get into March of last year and things very, very quickly got very interesting. We, in quick succession, got 3 different eviction moratoriums over the course of about 6 months. 2 of these are no longer in place. The CARES Act was the first eviction moratorium that came out right at the beginning of COVID. It covered properties that had any kind of federal funding. Oh, Eileen, I'm seeing notes that say that the slide didn't change.
Okay, let's try it again. So what I did, Holly, I just cycled to the eviction protection declaration and then back to the eviction moratorium. So I'm showing the slide advanced. If somebody can send me a chat, that'd be great. Still the old slide, nothing changed. It didn't, slide not moving. Well, thank you all for the feedback. Let me do this. Let me stop the share and come back in, okay?
While you're doing that, one of the questions that just popped up was what obligations does a landlord have to keep the property upkept under the law? Alabama has an implied warranty of habitability. That means that the property should be in good condition, fair living condition. Our law goes into a little bit more detail on that. It's got to have things like running water, hot running water, sanitary facilities. It does have to have heat. Interestingly, our Landlord-Tenant Act does not require air conditioning. Which I don't know about you, but I need it to live in the Alabama summer. But because I sat on the floor of the legislature the day this was argued in 2006, just, back when they allowed guests, literally the discussion came up was that it would make the prisons decreed uninhabitable if we said that people had to have air conditioning for a place in Alabama to be inhabitable. So I find that really interesting. But in general, a landlord has that implied warranty of habitability to provide a decent, safe place to live. One of the crappy quirks of our landlord-tenant law is that if your landlord doesn't hold up his end of the bargain or her end of the bargain or their end of the bargain on that, the tenant has a right to break their lease. For someone of moderate means, that may not, or low income, that may not be a possibility. Even if you're not in a housing market like this, you may be on a waiting list for months and months to move somewhere else. Certainly in the worst of cases, there may be the opportunity for personal injury suits, where a landlord fails to disclose lead paint, where a landlord fails to repair a known issue, and someone is gravely harmed as a result of that, failure to repair a broken roof beam or something like that. Failure to provide proper sanitation services. We see a lot of straight pipe cases where rather than having a septic tank, there's a straight pipe into the backyard. Those can lead to injury to the point where you see a PI case come out of it. Mold cases, someone mentioned mold. Mold cases are their own special heck, and I admit I am not a personal injury lawyer, and I refer those to PI lawyers where someone has clear damages from mold. Because at that point, that's what you're looking at is personal injury damages. You can't, under our current Landlord-Tenant Act, can't force the tenant to repair. Your right as a tenant is to break your lease and move. That becomes an issue when we're dealing with things like mold, because anybody that's ever tried to look at a mold case in Alabama knows mold is its own special hell. Every house in Alabama has it. It's a matter of what kind and how much. It's why our homeowners insurance policies don't cover it. And so proving that mold has caused personal injury level damages is always an interesting thing. Basic appliances are not part of habitability. They are not specifically included. The general rule is that if you rent a property that has them, they should be kept in good repair, but there's nothing in our law that says that a landlord has to provide something like a refrigerator. All right, someone mentioned the CARES Act. The CARES Act, as it applies to landlord-tenant, is actually not in place. It is currently covering homeowners, but the CARES Act itself has expired. The CARES Act was the first eviction moratorium. It was the one that covered any kind of federally backed property, which meant we had to go check a database on every single house or apartment that someone was being evicted from. If you had a federally backed mortgage, FHA, VA, USDA, Fannie Mae, Freddie Mac, you couldn't evict a tenant from a property like that. Public housing, Section 8 vouchers, VA HUD-VASH vouchers, anything where federal money touched your house or your rental property, you couldn't be evicted from it during the CARES Act, unless your violation of your lease was a danger to the other tenants or to the property itself, if you're lighting things on fire in there. We also very briefly, for about 6 weeks, Governor Ivey had her own eviction moratorium that said that we would not handle eviction cases in the state of Alabama at all. That expired last spring, so it is well past its expiration. The current moratorium that we're operating under comes out of the Centers for Disease Control. That becomes its own special thing. To give you a rough idea, we're seeing all kinds of appellate decisions. The most recent one is the Skyworks case out of Ohio, trying to grapple with whether the CDC has the right to do this at all. When this act came out, I wanted to look and see what the CDC had used with this kind of law enforcement-ish type power before. And the last time this particular power was used by the CDC, to give you a rough idea, was planes coming over from Ebola-ridden countries about a decade ago during the Obama administration. The CDC used this power to stop flights coming in from out of the country unless they were specifically handled in a unique way. Bringing people over, from Angola during the Ebola era had to be handled in a very specific way with quarantine at the airport. And so the CDC had the right to say, if you bring over a flight full of people that we haven't authorized, we can fine you $100,000, Delta Airlines. So that's where this right comes from for the CDC, just to put it in historical context. The CDC moratorium started on September 4th of 2020. It is still in place. It has been extended several times, and it is now extended through June 30th of this year. The form that you see, and I'm seeing notes that say it's tiny, and I apologize. If you Google CDC form, this is the first hit that comes up. This is the most recent version of this form, and you'll see that it has some check boxes that tenants have to say that they qualify. Previous iterations just had them sign at the bottom, and a lot of tenants didn't really read it to see if they qualified for CDC relief. But column A is whether their income qualifies, and you've got to earn below $99,000 a year, or 98 for a family, or $99,000 for an individual, 198 for a household with joint filers. So anybody who got the stimulus basically is going to qualify for the CDC declaration in terms of income. They also have to meet certain factors that would stop them from being able to pay their full rent. Some of those are things like having your wages cut, being laid off from work, some other loss of household income, or an extraordinary out-of-pocket medical expense increase. My next slide is going to have some pitfalls of that column B and issues that we're seeing come up as these make their way to court. It is important to note with the CDC declaration, and the most recent iteration says it at the bottom, it does not stop a landlord from filing for eviction. A landlord can still take this case to court. And in most cases in Alabama, the filing of the unlawful detainer action, the eviction action, is what triggers the eviction on your record that people are worried about in a background check. So this doesn't stop the cases from making their way to court. And that's an important point that has gotten missed in the public perception, is the media has told us that this thing is a castle wall. It's cheesecloth on a good day. There are a lot of holes to this thing that are getting exploited in the courts. And that's why I say it's important to acknowledge public perception, what people are seeing on CNN, what they're seeing on Fox News, what they're seeing on their local news, what they're reading on Google, versus what's actually happening in the courtroom on these. Again, it's not a castle wall. It's got to be affirmatively pled. Your tenant has to provide that CDC declaration. When they provide it is a really unique question. Is it provided at the point that they receive the 7-day notice? Is it provided when they file their eviction answer? Are they providing it after a writ of possession has already been issued against them? Those are really important questions that our courts are grappling with. In one case, I had someone who had a writ of possession issued against them and went into court and filed this document. And the judge said, I don't have, jurisdiction over this case anymore. I can't do anything with it. In another county, I had the exact same scenario, and judge said, all right, we're putting the brakes on this and we're going to go have a hearing on whether or not they're CDC eligible. There's not a lot of guidance out for our judiciary on how to handle that. We have a rule that came out last week from the Consumer Financial Protection Bureau that says that landlords have an affirmative responsibility to tell tenants that this relief may be available to them, that a landlord basically at least has to notify them that this rule exists. Some of our counties were already doing that. Landlords were having to file something with the court saying that they had either, been told by the tenant that they didn't qualify, or that the tenant hadn't provided them with the declaration page. But that was very spotty around the state. One of the CDC's requirements that has been beefed up in the most recent version of this form is a partial payment requirement. Your tenant has to be paying as close to their full market rent as they humanly can, is basically the CDC requirement. So if they've lost half their income, maybe they need to be paying half their rent. If they have, experienced a loss of income due to some of the other factors that we've all had to deal with during COVID, oops, your number came up and now your kid is quarantined from the 6th grade. That was me 2 weeks ago. It's going to require that you make partial payments to the best of your ability. And that best of your ability can become a judicial question. And these hearings can get really, really invasive on what you earn and how you're spending it. I've prepared clients that it almost feels like what you would expect a really bad bankruptcy 341 to feel like. Most bankruptcy cases, really don't have this invasive requirement that public perception would say that they do. These cases can get invasive. I've had clients have to pull their bank statements. I've had clients, have to go through their bills in testimony in district court to explain what they've paid and why they couldn't pay the full amount. I mentioned that this is a constantly evolving area of the law, and we're getting these interesting appellate decisions that just keep popping up. In Tennessee right now, the federal court for the Western District of Tennessee has come out and said that they don't believe that this is constitutional at all. And as a result, the Tennessee Supreme Court literally issues an order that says that if you're in these counties covered by the Western District, you don't follow these rules anymore. We ignore this thing because our federal courts have ruled it unconstitutional. And that is literally a memo that came out of the Tennessee Supreme Court. None of the federal courts that govern Alabama, none of our federal districts and the 11th Circuit have taken this issue up yet. So it is still valid law in Alabama, but you are seeing Landlords Council make some of these arguments that are coming out of the Ohio cases, out of the Tennessee cases, out of the Texas cases, about the constitutionality of the law. Because again, it makes sense on some level that the CDC can stop planes full of Ebola patients from coming over. The CDC having the right to issue a blanket eviction ban across the entire country is unprecedented. And I think we're going to be grappling with the constitutionality of that for a long time. It's important to counsel tenants that the debt doesn't disappear. This doesn't mean that you don't owe your landlord money. It just means that you can't be kicked out on the street for owing it right now. So as this thing has kept being extended, it's going to expire theoretically on July 1st. All that rent is still due on July 1st. That doesn't go anywhere. And tenants need to know that this doesn't eliminate their debt. It's not a quote unquote get out of jail free card. It's simply we don't have safe places to put this many people in shelter in the middle of a pandemic rule. And one of the big glaring, especially 1 year into the pandemic problems that we're having with this, the CDC declaration does not cover non-renewed leases. So if your lease is expiring in May and your landlord is giving you your 30-day notice right now, the CDC declaration doesn't mean that you get to stay until the end of June. CDC covers non-payment. It does not cover non-renewals. So if your lease is expired, you need to know, again, this is one of those things that where it's cheesecloth and not a castle wall. It doesn't cover expired leases. I will caution that one of the issues that we've kept seeing in court is that, as I showed you on the form, it requires a diminished income to succeed. We have a lot of clients on fixed incomes. So they were receiving Social Security, and COVID did absolutely nothing to change their income. If anything, they got a stimulus they weren't expecting. Those people trying to use the CDC has been a perennial problem in the courts. I think that because the public perception has been out there that you can't be evicted right now, they're filing this form, but in all honesty, they likely don't qualify. They didn't take a hit to their income because of COVID. And if you go and read that form, increased expenses as a result of COVID, general expenses, don't put you under the CDC. Medical expenses do, but general expenses don't. And so, if grandma's income didn't change at all because of COVID, but she was caring for 4 grandkids and had to feed them every day, and her expenses jacked up because mom and dad dropped them off to do virtual school at grandma's, those increased expenses don't put her under the CDC declaration. There is some guidance that tells us to be broad on what medical expenses were. For example, if you're a cancer patient at the height of the pandemic, when you were waiting in line to go to the Publix, you might have had your groceries delivered. that can be considered a medical expense. The fees to have your pharmacy delivered to your house can be considered a medical expense in this context of, back last April when we thought that going to Publix could, and in some cases was a vector for infection. That expands what we considered a medical expense a little bit to some of these delivery fees for very basic needs so that people didn't have to go out. Eileen, okay, next. So there are a couple of counseling tips that I want to make sure people know about as they're looking at this. If the client has applied for rental assistance, and the next few slides are all about millions of dollars flooding the market, we need to know if that tenant has applied for rental assistance, where and when. That's one of the factors of the CDC is, have you applied for any kind of rental assistance? We need to know if they receive any kind of housing subsidy, because that may increase or decrease their eligibility under the CDC. We need to know if they have what I call the COVID factors still in play. As people have returned to work, as life has started returning to normal, how is their income still impacted? As much as I hate to say it, and I'm going to use my least favorite word here, are they a deadbeat sitting at home on the couch collecting a check, or are they someone who, for various reasons, genuinely cannot return to work at their previous employment? Some restaurants closed. Sometimes, if you making the transition from fine dining to fast food is not something that a person can do for a number of reasons. But you're looking at whether they still have those COVID factors still in play. Are they now no longer in need of getting their medication delivered to their house? Are they now able to return to work in some way, or has their employment been permanently impacted by COVID? We know that as we start seeing vaccinations for things like nursing home workers, those are still opening back up. We know that as we start seeing children returning to school, that opens back up, but we're looking at whether the COVID factors are still in play. And as we look at permanent income changes for people that came out of COVID, they lost their job in fine dining and now they're working at Applebee's. You've really got to look at their long-term ability to afford to stay. If this place is still going to be unaffordable in July, we want to counsel them on what their ability is to look at somewhere else and where else they want to go, so that we can help them move on with dignity and hopefully avoid an eviction on their record. Anecdotally, in the 13 counties that my office serves in North Alabama, tenants always have a big concern about that eviction on their record, and when that kicks in and where that kicks in, because there's no legal definition of an eviction on your record. Most landlords consider it the filing of the unlawful detainer. Some tenants say, I haven't been evicted unless my stuff has actually been put out on the curb by the sheriff. But having that eviction on their record is something that they are very keen to avoid. And in some cases, we have found judges much friendlier than they have been in the past about sealing eviction records to pull that off of a tenant's permanent record, as it were, where folks were gravely affected by COVID and have worked out a settlement to leave with dignity. So as you're mediating cases, as you're counseling clients, that may also be something that you'll want to know your judge, but knowing if that's an option at all is whether a seal of the case for a graceful exit or for a full payoff is an option. I'm going to stop there and answer a couple of questions before we go into talking about money, my favorite thing in the world. Okay, let's see. And I just see, do the materials to be provided include these materials? They do. I have a friend that has been sued for conversion for removing items after 14 days. Judge issued a very specific order requiring written permission to enter the property to gather belongings. Tenant did not show on the scheduled weekend. Belongings were hauled off. Any thoughts? I believe that until a writ of possession has been granted, that landlord doesn't have the right to re-enter absent some kind of extreme emergency like a flooding unit or a fire unit. Absent that, without a writ of possession, and you don't say whether the order was a writ of possession or not, if the tenant failed to enter, you still don't have the right to remove property without the writ. Is there a monetary cap on the initial deposit payment by a residential tenant? What is it based upon? That is set in the code. In almost all cases, your deposit is going to be capped at 1 month's rent. They certainly can charge additional fees for pets and for other obvious things that will do damage to the property. But we don't have that first month, last month rent that we see in Alabama. We are looking at 1 month rent. Is there additional HUD moratorium in place through June separate from the CDC one? There is, but that specific thing covers certain types of public housing and certain types of subsidized housing. We also have a HUD moratorium that covers foreclosures, which is outside the scope of what we're talking about today. We believe that the foreclosure relief, it currently is set to expire on June the 30th. Everything that we're seeing is indicating that that's going to get pushed into September. And the reason is, and I'll seg into this, we have the money in hand now for most of the rental assistance programs. The money for homeowner assistance programs is still waiting for distribution to the states. In fact, the RFP, the proposals for states to get that money closed last Friday. So we think that we will see the foreclosure programs extended until we can get the financial assistance money out, is what we're hearing out of the Biden administration. Did I say that mobile home lot leases are covered under the URLTA? They are. I read it like you do to say dwelling units. I believe that mobile homes are an ejectment. Most judges that I've found disagree with me. They say that if you are living in a mobile home but renting the land, that it can still be an unlawful detainer, that it can be a landlord-tenant eviction. I don't believe that that is right, because the act of moving a mobile home is significantly more involved than moving belongings out of an apartment or out of a rental home. But that is the current lay of the land. So we're dealing with a lot of rental assistance money coming into the state of Alabama. Right now, there is $263 million up for grabs. The largest factor in that is the state funding program, but any municipality, any city or county that had a population of more than 200,000 could also apply to pull their money and run their own program. And again, $263 million to pay back rent and back utilities. That is a huge, gargantuan number like nothing we've ever seen before for this kind of assistance. More is coming. That $263 million actually came out of the second stimulus act. So that money still came out of the Trump administration. The third stimulus has more money for this, and it hasn't been distributed yet. So that's why I say $263 million and more on the way. If we can go to the next slide, Eileen. So most of that 263 is getting distributed by the state through the Alabama Housing Finance Authority, and they've outsourced it to a company called Horn. Tenants can access the application for this, and landlords can access the application for this at eraalabama.com. Both landlords and tenants can apply and receive the funding. The catch is that a landlord cannot evict and receive. So if you get these funds, you either have to dismiss the eviction that you've got going, or you would have to, be paid and then refile if you're renoticing. But you can't dual track. You can't receive the money and evict. You also can't get it if the tenant has already left the property. The purpose of the money is to keep roofs over heads. So if the roof isn't over their head anymore, can't work. ERA is paying substantial amounts of money. The average that I'm seeing so far is in the $16,000 range per person. It can include rent as far back as March of last year. It can go forward up to 3 months from there. So, sitting here, it could pay May, June, July, conceivably. For people who have ongoing COVID factors, it can keep going. You can reapply every 3 months to keep pushing more of it. It can include your utilities, electric, power, water, gas, trash. The way that these federal funds were worded left some local control. This matters because ERA Alabama does not cover certain things that landlords really want it to cover. It does not cover their late fees. It does not cover their court costs, and it does not cover their attorney's fees through the statewide program. So when you're dealing with a tenant who is being evicted, leaving out those three factors can frequently make the deal fall apart, especially for folks who are in subsidized housing. I've had clients evicted for owing less money than the Starbucks latte that I bought the morning that I went to court with them, which was a sobering thought. in some cases, those late fees, court costs, attorney's fees are more than the actual amount of rent due in the first place. So ERA's decision not to cover that is something that you need to know. They have a very lengthy lag time at current. The last time I called, they were still working through applications submitted on March 3rd and 4th. So almost 2 months ago. When this was first announced, it blew up. There was a giant media blitz about it, and it is taking a lot of time to get people through the system. It is the only option if your tenant has any kind of housing subsidy, if they're in public housing, Section 8, low-income housing tax credit. Basically, if any portion of their rent is income-based, is what we think of, they're going to have to go through ERA Alabama, even if they live in an area where they would be eligible for local money.
Sorry about that.
So several municipalities in Alabama have applied for the local funding. I've put up the websites for the ones that are currently in existence and open or will open in the next week. The city of Huntsville's is open. They're doing something really unique and working with legal services. We are on every single eviction docket in Madison County, trying to help tenants apply for these funds if they're eligible for them and stop eviction at the point of the courtroom, which I think is really cool. Birmingham will open its application shortly. Huntsville, by the way, is covering late fees, court costs, and attorney's fees. I am not sure about Birmingham, but the last that we had heard from them, they intended to cover the same things because they were hearing what we were hearing is that the state program not paying those things were making deals fall apart. Montgomery County has its up, as does Baldwin County and Mobile County. Madison County received its own separate fund. Okay, and I'm seeing Birmingham open Monday. I was thinking they were opening this coming Monday. So that's good news. Madison County has its own money. They haven't decided how to spend it yet. I believe Jefferson County has gotten its own money and has not developed its plan yet. If you live in an area where they have not decided how to spend their money yet, you're still going to apply through ERA Alabama, and there is some kind of MOU where ERA Alabama is paying back the counties. If you've got someone that lives in one of these local areas where things are covered, applying through your local program is going to be your best bet because they are going much, much faster. The Huntsville program is cutting checks within 2 weeks of application. And again, ERA is still looking at applications from back in the first week of March. Couple of pitfalls to know when you're assisting a client in applying for these. Most of them are based off a software platform called Neighborly. It's pretty friendly to generate. In addition to having a regular desktop computer version, there is a web-based version. Folks can use their camera on their phone to upload their documents. I believe that it's a pretty friendly application for most people who are moderately tech savvy, but it does require proof that your increase in expenses or decrease in income is COVID related in some way. And for some people, that's been really hard to prove. You need to be able to show that you had a positive COVID test result and had to leave work, or that you were quarantined by your employer, or that you were at home with children who were of an age that they couldn't be at home alone and had no other childcare options. So some of that COVID related proof, we're still working out the kinks on how to provide that in a way that complies with the Treasury regulations that cover this. It does dual track with evictions. If anyone on the call has ever dealt with foreclosures where you're applying for a loan modification while at the same time the foreclosure is proceeding, that can be really frustrating for a homeowner. And in this case, it can be really frustrating for a tenant because you're simultaneously working to get the landlord paid while the landlord is trying to get the tenant out. And the lag time on some of these is making them difficult to get money paid in time. That's why I tell people if there's any option other than ERA Alabama, go with your local option. Your landlord has to agree to accept the funds. If they don't, the tenant can in some cases get the money directly so that they can use it to move on to another place. But the landlord has their own part of the application that they have to complete. And so what we're finding is we're getting landlords that are applying, but we have tenants who are not tech savvy to do their part, or we're getting tenants who apply and the landlord either isn't tech savvy to do their part or doesn't want to supply the financial information needed to get their part done. Providing a ledger. It always shocks me how many people just don't have a ledger. And again, the document submission process is, I believe that it's no more complicated than turning in my 6th graders' homework through Google Classroom. But that is a level of tech savvy that some people don't have. There is no way through any of these to actually seem to talk to a living human. ERA has customer service people to answer general questions, but those people are not the same folks who are reviewing the applications, and they generally can't look at your application and tell you what you're missing. The same thing is true for most of the local programs. If what your client wants to do, if what your tenant or landlord wants to do is talk to a living, breathing human, these ERA applications right now simply don't allow for that. With that said, there is a great deal of money up for grabs that I believe is going to dramatically lower the amount of evictions that we see. And again, it's been shocking to me to start seeing $15,000, $16,000 worth of rent paid for people. I've never had that ability as a legal aid lawyer to go look for money and get a tenant's rent paid and get them back to housing stability. So that's been really great. This is money that is use it or lose it. And ultimately, you know, what I tell people is this is really a small business stimulus. This money is ultimately going into the hands of landlords, not the tenant. And this is really a way to ensure that affordable housing still exists more than just about anything else. I know that my time is running thin, so I've put my contact information up here. The 536-1544 is my office cell. I'm one of the easiest people in Alabama to reach. You can call me, you can text me. There is no secretary that answers the phones at Legal Services. It's just us. And you've also got my email address.
Thank you, Holly. This has been incredibly informative. And I think it's really important, you know, that we understand the law and what the current guidance is and some of the challenges, especially that tenants are facing. And during the next hour with our panel, we have attorneys and mediators who handle these types of cases, but also provide representation to landlords. So we're going to be talking about that in just a minute. But Holly, this has just been incredibly informative. I'm sorry we had some technical issues, but you handled it sterilely. I appreciate it. And you're welcome to stick around for the second hour. We value your input. And with that, I'm going to go ahead and stop sharing this presentation. And we're going to get ready to transition over to our mediation. Holly, any closing comments while I'm setting up?
Absolutely. I'm always happy to answer questions. We get these a lot, and I know that representing tenants is often not a profitable venture for a lot of people, and so there's just not a lot of folks you can call for advice on it. You know, outside of that, make sure that to the extent that you can, encourage people to apply for rental assistance. That is what it is there for. It is an unbelievable amount of money. We want to make sure that it makes its way into the hands of ultimately the landlords who have propped up affordable housing for the past year through all of these moratoriums through no, you know, kind of force of their own. And ultimately we want to see a reduction in evictions. You know, I call it the Charlie Brown's puppy farm problem. We always want to believe that these people find somewhere to live, that grandma takes them in. That's not reality. This is how we see people living in their cars. This is how we see Tent City. This is how it happens. And so any actions that we can take that keep a roof over people's heads are in the best interest of society at large, ultimately.
Great. Thanks, Holly. And hopefully now, let's see, let me put our title slide back up. We've got a few comments in the chat box real quick before we transition. We've got some folks who have to leave. I think Holly has probably answered all the questions. We will be sending the PowerPoint slides out after the program. It won't be today, folks. I got to tell you that. We've got over 200 folks on the call, so appreciate your patience on that. But we're going to go ahead and transition then into our second phase. And hopefully everybody can see the slide that has the title Landlord-Tenant Evictions and Mediations with our panelists. I will tell you, I'm driving the slides, so it may be a little challenging to handle the chat box as well. But a lot of great information, and we've got I consider it an all-star team lined up for the second half. We have Brian Oakes, Jamaria Moore, Brian Wallace, and Garrett Chambliss. I just want to mention briefly about our next group of panelists and tell you a little bit about them. Brian holds an undergraduate and graduate degree in communications from the University of Alabama at Birmingham. He obtained his Juris Doctorate from the University of Alabama. He has an extensive practice that focuses on personal injury, domestic property, and employment law. And he is an registered mediator with the Alabama Center for Dispute Resolution and Civil, Domestic, and Domestic Violence Mediation Programs. And he is also registered as a foreclosure mediator. In addition to his mediation practice, he has an extensive litigation practice. He's an educator as well, teaching at the Business School of Calhoun Community College since 1996, and in the Paralegal Studies program at Calhoun College's Paralegal program in 2009. And so very broad, extensive experience. Jamaria Moore is also an experienced mediator and attorney. She's registered with the center as well. She graduated cum laude from the Alabama Agricultural and Mechanical University in Civil Engineering. And in 2000, she graduated from the University of Alabama in Birmingham with a Master of Business Administration. After completing the Birmingham School of Law in 2006, she opened her own law practice and became a founding partner at Sperling & Moore PC, where her practice focuses on all aspects of family law, including divorce, custody, support, equitable distribution, prenuptial agreements, and adoption. Her practice also includes personal injury, administration, business formation, and general litigation. She serves as a municipal judge for the city of Birmingham and as a special district court judge in family court. And then we're also joined by Brian Wallace. Brian Wallace has formed his own law practice in the Florence area, and his firm's dedicated to providing creative mediation solutions and effective legal representation and counsel to his clients. If you missed our earlier conversations, Brian is predominantly focused on mediation and helping parties resolve their disputes. He earned his doctorate from the Faulkner University Jones School of Law. He's also a registered mediator here with the Alabama Center for Dispute Resolution, mediating a wide variety of cases, including collections, business, landlord-tenant disputes, property disputes, in addition to domestic relations. He's also on the appellate mediation roster maintained by the Alabama Supreme Court. And then our last panelist joining us is Garrett Chambliss. Garrett is an attorney and associate with the law firm of Chambliss, Math and Carr in Montgomery, Alabama. His firm represents clients with consumer and commercial litigation, bankruptcy, residential, commercial foreclosures, and landlord representation. He earned his Juris Doctorate and LLM from Faulkner University's Jones School of Law, and his areas of concentration on mediation include landlord-tenant disputes, contracts, collections, construction, elder law, and real estate, among others. So I think we've really got a great panel to speak with us this afternoon, and hopefully you can ask some questions to the chat box as we go along. And excuse me while I am admitting some folks who got accidentally bumped out of the program. You know, I think the pandemic has posed challenges across the state, not just in Alabama, but across the country, but we're focused in Alabama. And it makes you wonder, what is the wave? What is the next wave coming? And I think, you know, we've seen these moratoriums come into effect and assistance for landlords and tenants. But one of the things before we begin our discussion is I just wanted to give you a snapshot of what's been going on in Alabama from March of 2020 to March of 2021. I reached out to the Alabama Administrative Office of Courts and I asked for a report to give us a snapshot of what's going on with evictions and unlawful detainers. And so, as you can see, during that year, we've had like 47 eviction cases. Now, these are cases that are filed in court, but there are over 6,000 cases that are unlawful detainers. And what does that mean for the future? Where's the concentration at? Well, this chart will show you what it looks like by county, because I was fortunate to be able to have the Administrative Office of Court break down the unlawful detainers by county. And then there's some areas such as Bessemer, Enterprise, Eufaula, and Pell City that were broken out separately. But I think one of the things that is interesting of note is there are two counties that don't have any filed, and they're in Washington and Lowndes County. But the counties with the highest amount is, you can kind of guess, are the metropolitan service areas, or I call it somewhere along the I-65 corridor, where the largest are like in Jefferson County with 2,140, which accounts for 35% of the unlawful detainers. Mobile's at 8.4%, Madison 8%, Montgomery County 6.6%, Bessemer 5.4, Shelby and Tuscaloosa just over 4%, and the rest of the counties are at 1% or below. And so I think this is an indication of things to come. And I think, you know, one of the things we wanted to do, we always talk about litigation, but we have some tools available to you through alternative dispute resolution that might be helpful to your clients. If you're an attorney, you know, mediation does offer an option for your clients to consider to try to get some sort of a resolution without having the courts make a decision. And so hopefully during the next remaining time that we have, and we may go a little after 1 o'clock since we got started late, is we're going to ask our panelists to talk about what you see on the slide. Why mediate? What's the advantage of mediating? When's the best time to mediate? And how do they set up the mediation for a positive experience for all the parties? And we also know that, and Holly touched on this, is that, you know, sometimes it's rights-based mediation. Tenant doesn't pay rent, the landlord has the right to get paid, you know, and there's might be a power imbalance. And so we kind of will hopefully talk about that and what mediators and how they can help both parties have a positive experience. So before I begin, though, I do want to ask our panelists, Brian and Jamiria and Garrett, if you've had any comments you'd like to make before we launch into our discussion.
Thank you for putting this together today, Eileen. It's a good program, been good so far. I know that it's informative. We were in unprecedented times, I guess, in terms of what we do for a living, as well as, you know, on the consumer side. I think, as we all know, this is as neutrals and mediators and people that appear in mediations, you know, we're looking for a win-win here for everybody. A lot of times that's a soft place to land for the tenant. A lot of times it's just getting the landlord possession so they can get the unit re-rented. I think this is going to be a good program. I appreciate you doing all the legwork and putting everything together for us today.
No, very grateful for y'all volunteering your time. All right, so let's kick off our discussion, panelists. What's the incentive for the parties, the landlord or the tenant, to mediate?
Money.
I guess I can go just to say this is Jamiria Moore, and again, Aline, I think I really appreciate it. The first half was amazing, and it brought a lot of things to light. But definitely, the incentive to mediate is to, number one, expedite time and possibly come up with a reasonable negotiation so that the parties can resolve it. Hopefully a win-win, but definitely money and time so that we can try to get the landlord their property back if that's the case. And you can, when you mediate, of course, it is flexible and save time. So I look at it as a flexible opportunity for us to craft great agreements that people can adhere to. I think that's the major reason that you want to mediate, so that you can get an agreement that people can actually do, and it makes sense for everybody. Now, it may not be a perfect agreement, but it can be something that people can live with.
Yeah, Eileen, this is Brian Oakes. And actually I may be showing up as someone else because earlier,
Hi,
I had difficulty getting in, and so I panicked and reached out to one of my law partners, and John Tomlinson, who practices in Birmingham, and he sent me a link, so that's why I'm listed as him. So I think I accidentally piggybacked on his link, but in any event, yeah, I think that Jamiria kind of hit the nail on the head, particularly from the landlord's perspective. You know, a lot of times the landlord really, money's great, money's good, but the landlord is typically looking to the future. So if you can fashion a situation that gets the property back to the landlord in as close to re-rent ready position as possible, I think that is as important to the landlord as getting any money that was due, because once that relationship's gone bad, you're ready for a new one. So I think that there's a lot of flexibility there when you are fashioning a mediation agreement, you know, from the landlord's perspective. I think a lot of times perhaps from movies or television, we think of the landlord as the ogre standing there, wanting their pound of flesh. But in reality, the landlord just wants to move on to their next dollar most of the time.
And getting that next dollar without having to spend another dollar has been paramount in my representation of landlord. Don't do that anymore. But when people come into my office and we sit across the table, I don't put everybody at the same table all the time, but when I'm sitting across the table from a landlord, it's been my experience that, we're already at this point. It's a sunk cost issue. We don't want to spend any more money. How quickly can I get that? How can we get this unit re-rented? And in fact, I shared this the other day with my colleagues. Maybe 2, maybe 3 in 10 would have me pursue judgments. By this time, if they're in this situation, they've got no money anyway. If they're judgment proof, maybe not. If there's a little bit of money, but largely the landlords that I've dealt with have just wanted to get their place back and get it back in a condition they can re-rent it quickly.
Absolutely.
Yeah.
Also, another incentive to mediate is just kind of getting around those harsh timelines. So much of this is 7-day time frames, and tenants may need, an extra weekend to get out, and landlords could accommodate, if we have tenants that are also willing to, maybe set up a payment plan in the future or something like that. And there's ways to work out, more of the smaller details, getting the place cleaned up and, applying the security deposit, and, that kind of thing. That it's actually easier to work out in a mediation than, just going in front of the judge for a quick hearing on possession.
Mm-hmm. And we can work out details inside of our process that a court is probably not going to have the time to work out, like Garrett alluded to a second ago. The cleanup and the issues with, if we've got pet problems, if we got other things, this is going to go a long way inside the process of being able to address those details and to get that unit returned to the landlord in a timely manner, and to give the tenant a graceful exit, leave with some dignity. I like how our speaker put it earlier about, to move with some dignity, not involve law enforcement, worst case scenario is, maybe a judgment, maybe a consent judgment, as long as somebody's paying a little money, we don't report, so there are ways around this, but there are ways around this inside our process. And we'll take the time that we need to craft something like that, where you're not going to get that typically, in a more formal
Brian,
setting.
I think we just had a little technical difficulty. Would you mind repeating your last comments?
Sure. I think that inside the process that we have, and we had an internet blip earlier, is why you might have seen me on my phone and then back here. So if I go away, I'll come back. But, inside our process, we can do things in my conference room or in my office that a court is typically not going to have the time, or these are not issues that we're going to address inside a courtroom typically, as far as cleanup or pet issues, or I'll give you 7 days to get out. We want, the timelines here are such that we can craft things inside our process. Our previous speaker put it really well. And if I'm the tenant, a little bit of grace is going to go a long way here in terms of, moving with dignity, not involving law enforcement, not having your kids seeing your stuff put out on the curb. If we can craft something like that and say, all right, look, we're going to work this out, but you've got to agree to make sure that, the place is clean, my appliances aren't damaged, everything is okay. If I'm the landlord, those are my thoughts. If I'm the tenant, I'm thinking, okay, I've got to regroup because I got to have somewhere to live in 2 weeks. I know that, time frames, and that was an awesome, graphic from earlier with the roadmap, but I know that time frame wise, you can't get a lot done in 7 to 14 days, but inside our process, you certainly can. And it would allow us to craft things inside our agreement that we can be a lot more detail oriented inside our agreement.
Now, one thing I think that was mentioned earlier, just to kind of bring it back, where the incentive to mediate, especially on the tenant side, is possibly negotiating out that this is not going to go on my record, that this is not going to be a part of alleviating me from being able to get additional rental somewhere. And it may be a tenant that was at one point an excellent tenant. And of course, something happened and the landlord and tenant may have a relationship that just kind of went south at the point that the rent stopped coming in, but there could be a reason. And I really believe that with mediation and just the ability to sit down and talk when people come to the table, things are really can be hashed out, just like everybody else on the panel said, that may allow the landlord to say, hey, I didn't know that was going on. Maybe we can craft an agreement that will give you a fresh start for next month. And we put some remaining balance on the backside. So the incentive could be that we could save the relationship. I know that may not be something that we show, but we gain that perspective as you shown on the slide, but it may allow us to maybe say, hey, we can save this. And for other reasons. So I just wanted to throw that out there. It may not just be the eviction. It may be that you can save the relationship and craft something that's very similar to things that we do with foreclosure mediation, where things may go on the backside, where you may pay it monthly in addition. So I just wanted to add that to what we're discussing.
And I do want to reiterate and I know that everybody on this call knows that that's the thought of having an eviction on your record or some legal process of removal on your record is awful, but I cannot iterate that enough that it really, it's almost in the rental world, it's almost the death penalty because the overwhelming majority of landlords that I'm in contact with, represent, what have you, they search the public records. They if they don't have access themselves, they come to me or some lawyer, another lawyer, and the name goes into Alicourt. And I can tell you that the overwhelming majority of landlords will just immediately, when they hear that it's even filed, the end result doesn't matter most of the time. It's the fact that it was filed, because if somebody had to go to the trouble to file the case, I don't want that kind of trouble. And so I think that's a major, has to be a major motivational factor on behalf of a tenant, because it is the scarlet letter. I mean,
I think his sound went away.
Right. Brian, it looks like we may not have your audio. So, and it may mean that you might need to come back in. You're making some excellent points and considerations, and definitely there is incentive for both the landlord and the tenant to come to the table with the help of the mediator.
I was just basically saying, I'm sorry, I think I have a short in my in my earphones. It's just been one of those days. But it's just, yeah, it's the scarlet letter for that case to have been filed at all. The end result doesn't matter.
Eileen, I think we have a question in the chat box that just kind of relates to programs for providing free mediation prior to filing for landlord and tenants to nonprofits and such. I can say I'm in Jefferson County, and I've been called to offer pro bono services in some mediation cases, which I normally would do. I'm not sure of any programs, but a lot of times if the attorneys are out there and they are looking to get some assistance with mediation, if you call some of us, it may be that we're looking to just get some practice and can assist you in that. So I think if you're an attorney, which I've done in the past, reached out to see if I could get someone to help mediate something that I thought would be a better situation if it was mediated versus litigated. So I'm not sure of any of the programs, but I do know just putting the call out sometimes helps.
Sure, and this is Eileen, and I'll share with you, and I'm sure everybody can see the question, but for those of you who are dialing in, the question was, is there a program for providing free mediation prior to a filing for landlords and tenants to which nonprofits can refer clients in distress? And then the second question is, and if I shift, it's because my camera's in front of it, has the bar section considered creating one to address rental assistance program issues to expedite assistance or resolution? So let me just talk for just a moment without taking too much time for the panel. Is all of our registered mediators here with the Alabama Center for Dispute Resolution are asked to give 10 hours of pro bono time a year, and many give more. And so for those of you who may not know, you can search for a mediator at alabamaadr.org. That's the Alabama Center for Dispute Resolution's website, and that's alabamaadr.org. And you can filter it as a practice area to landlord-tenant. And I always tell folks, pick up the phone and call them and see if they're willing to do a case pro bono. I have found that our mediators are very generous, and we publish statistics each year from our registered mediators, and they're very generous with their time. So, and we post those on our center's website. So I would encourage you to, as a first step, is try that approach. The other, to answer the second part of the question, is has the bar or the section consider creating a program to address rental assistance issues? Let me just tell you that I'm a member of the State Bar's Pro Bono Task Force, and there is a subcommittee on access to justice and mediation. And one of the things that we have been working on this year is assessing needs, working and surveying the courts to find out how mediation can help their courts. And so we've received a good response back on the types of cases that the courts need help with. We're about to send out a survey on, well, just tomorrow, to all our members of the dispute resolution section of the State Bar, as well as to our registered mediators here with the center, asking them about their interests and willingness to participate and help litigants and the courts with providing pro bono mediation. So there isn't one big formalized statewide program out there, but we do know that there are various courts around the state do have pro bono mediators involved. And this is something that we are taking a look at because we want to help, our litigants, our Alabamians, our courts, try to resolve their disputes in a way that they can come to an agreement that they can live with. And we've heard many of the great reasons why there are incentives to go to mediation. So I will let you know that we are working on that. And we will be presenting a program at the Alabama State Bar annual meeting on access to justice and mediation. So if you're going to be attending the State Bar's annual meeting in July, we welcome you to join us. Someone asked the question, is there still a district court volunteer mediation program? In Alabama, there are about 4 active district court mediation programs throughout the state. In the past, there had been about 9 of them back when they had funding to pay mediation coordinators, but that funding went away. However, Jefferson County has a mediation program. They're looking at revitalizing that in the small claims court. And so just to make you aware of that, Madison County has one, although each court or circuit has taken different rules and guidance to how to respond to COVID. So you'll need to check with them. But send me a separate email, private email, and I'll be happy to respond back to you. Our law school clinical mediation programs have been active up in the Tuscaloosa area. Here in Montgomery County, we have pro bono mediators through the Faulkner ADR programs. They serve a variety of counties in Watauga, Elmore, Montgomery, Dallas. I've been told that there are some mediations going on down in Lowndes County. Mobile County and Family Court has some pro bono programs. Believe it or not, the center has funding to pay pro bono foreclosure mediators, and we have foreclosure trained mediators. You can search for them on our website under the heading for the public. It's court ordered mediation, and we have that funding thanks to some money from the Alabama Law Foundation. So we are looking at ways to address and try to help the courts and litigants with a variety of different issues in areas through the use of pro bono mediators. So just to make you aware of that. And if you have any great ideas, just shoot them to me and I'll share them with our Access to Justice and Mediation Subcommittee. But great questions. And we are aware that there's a need and we're trying to find ways to help. So getting back to, we've talked about great incentives for mediation, but who needs to be at the table? And so panelists, who all do you think needs to be there for the mediation or to be considered?
Well, definitely the landlord representative or someone that can make a final decision. There is nothing like mediating and then someone has to make a call and then you have to be put on hold and then that person's not available. It tends for a long day in the past, but I love to see and make sure that we have someone who can actually make a decision to enter into the agreement. So that would be the landlord or the representative. Of course, we want the tenant there and anyone else that may have any type of connection with that particular lease. We want to make sure that they're there. And some in just past experience, many years ago, of course, you would maybe have a tenant that lived there and they may have a co-signer who may be a mom or someone else. I see that a lot. And sometimes you want to make sure that everybody is present that has something to do with that lease. And of course, if there are any attorneys involved, if the landlord has an attorney represented, yes. So and I'll tell you, I had an experience, and I think I shared it with our counterparts here at another time, that some of the agencies that may be involved in helping the tenant with rent, they may have an interest in assisting with that. So that's who I say I'll leave the other to the other panelists if they would like to share as well.
Yes, Ms. Moore, I agree that, the parties and the attorneys are valuable. Attorneys will help the parties, guide them through the mediation process if they're unfamiliar. And of course, explain the law and stuff like that. So like kind of work out the actual legal issues for each side. And then of course, we don't have it listed on the slide, but a true neutral is always important in these things. A good mediator who's willing to be open and to work with both sides and do their best to, come to an agreement.
Another option you may want to keep in consideration, like we do all other mediations, as you find out about these individual cases, there may be someone important, more so in the tenant's life, that is a resource for them. So it may be helpful to have that resource present, whether that is a relative or a close friend or someone that can help bridge the gap as to what needs to be done in the future, whether that's from an emotional standpoint or some type of financial standpoint. Not just the co-signer thing, which is a great, yes, you need to have that person there, but more of a resource. And that may not be present in every case. That's going to require knowing a little bit from mediation statements or whatever about that.
I agree, Mr. Oates. Having a confidant it would be useful, especially in these mediations where the parties end up caucusing. And if it's just a single tenant sitting in a room by herself, waiting for the mediator to be coming back and forth, it's better for the tenant to at least be able to kind of have a sounding board, somebody else to speak with about these offers, counter offers, that kind of thing. So it would be useful, for the tenant, as long as there's no confidentiality issues, that kind of thing. But
Yeah.
It would be nice for the tenant to have, someone else in there to help them kind of, go through those decisions.
Tend to work with a lot of the same folks in terms of people who do a lot of trial work in the counties that I do a lot of mediation work in. And generally, if I have an attorney who comes to me and says, listen, I know that you don't allow anybody to come. I know that, under the rules, we have to have permission to allow other people to be here. But, I really think this is going to be conducive to trying to get this done. Typically, I take their word for that. And as long as it works and everybody agrees, we're fine. My problem is more times than not, when other people are allowed to come in, what I get is more blowing up bridges than building bridges. So I kind of have to take that with a grain of salt in terms of my decade of experience doing this. Yeah, sometimes it works. Most of the time it doesn't work. And I have to kind of evaluate that on a case-by-case basis. A lot of times it does. People do need to have somebody to talk to. especially if they're in a pro se capacity, and then you have to kind of shift gears because the rules allow for other things there. But what you don't want, in terms of a settlement, is to have the whole thing blow up because you have other voices that may not be conducive to your settlement efforts. So
Yeah.
it can go both ways.
Oh, I agree with that totally. I think that it's, in my mind, that situation would be more so for somebody that's had something catastrophic go on, and they're just not going to be able to deal with the situation without some type of support. I would not necessarily default to that.
Yeah. Sometimes less is more.
So panelists, when's the best time to mediate?
Quick.
Early.
Better.
Early.
As soon as possible.
By the time this gets into court, I can envision a scenario where this has gone on and we've been to a pretrial and they've said, well, why don't we, this could turn into a month, 6 to 8 weeks, and the landlord is already out this rent. The tenant is worried about what's going to happen. The landlord's worried about his or her property. I shared with my colleagues the other day, I'm making breakfast, right? And I hear a crackle, not the kind of crackle you want to hear in the morning, snap, crackle, and pop, but I hear a crackle on my stovetop, and I smell smoke, and of course I turn the thing off. I've ruined my stovetop, right? And so I get online and I start looking for replacement stoves, and I'm finding $400 or $500 stoves. My wife informs me that the appliances need to all match, right? So, my $400 stove ended up being about a $2,000 one, and I'm thinking, golly, if I were and I'm thinking about how this CLE is going, and I'm thinking, if I were a landlord and had to replace a stove, a fridge, damage from pets, all this other stuff, a typical rent, $500-600 a month up here for, just an apartment in my corner of the state, you would have to be in that apartment 5 or 6 months for it to be, about the kind of money you're talking about to replace things that might get damaged. If I'm a landlord, I want this done fast. I alluded to sunk cost earlier. I want to get into court or get this settled as quickly as I can, because the amount of offset in terms of rent versus replace, not just lost income, but lost rent, lost income, replacement. The quicker I can get in there and make sure everything is okay, the better off I'm going to be. The flip side of that is, if I'm the tenant, the quicker I can get this resolved and find a new place to go, this is off my shoulders. So, time is of the essence here. It needs to happen right out of the gate. And I think one of the things we can do as neutrals, especially with the subcommittee work that's being done, and maybe the ability to get people in without, 2 or 3 settings and, issues with the court. By the time, if we can make that happen sooner than later and catch it on the front end, everybody wins, right? The neutral gets it out of the way. The landlord gets their spot, gets their property back. The tenant gets a new place to live and gets this off their shoulders. Sooner than later works better here.
Great. We've got a couple questions that have come in through the chat box, and it ties back to talking about the parties. And really, I think the conduct of the mediations is, do you believe it best that the parties be physically present as opposed to being on the phone, particularly if you're talking with an attorney who then calls the client and can put their spin on it, and then the attorney gives you an answer? And a second follow-on question is, how often do you mediate virtually? And I guess that's something that I would pose to all the panelists, given, especially during the pandemic. What are your preferences, or what is your experience shown during the past year?
I think in the last year, I've probably mediated a handful, maybe less than 10, probably 6, 7, 8 virtual mediations, which I would have thought it would have been much higher than that. In fact, I had the previous discussion with you, Eileen, about how shockingly low the percentages are typically for virtual mediations, even at the height of the pandemic. But my observation has been most people still want things live.
Now, I would agree with that. We have had several mediations that were virtual, and what tends to happen if you have a tenant or even a landlord that's not computer savvy, it can go south really fast, especially when you're looking at breakout rooms. And then sometimes it's good if there is an attorney, if their client is in their office with them and you're actually being able to do the mediation via virtually, the attorney would have more access to technology and understanding. So what I've seen is it has not been like this vast amount of individuals wanting to do it virtually because of the challenges that you have. I was talking with some other colleagues where they were putting on where people were actually driving along the road, trying to be on mediations and in court and all kinds of different things, which causes, of course, a safety issues. So I am always looking I think when you can look somebody directly in their eyes, you have a better chance of possibly getting that mediation handled. You can get a feel for what they're truly seeing. You can't see everything in the room. It's just like now I've shoved all my junk to the side. You probably can't see all the stuff that I have in my office. So you don't know who's all there. It can get complicated. So at this point, I would still say that I like in person better and looking forward to getting back to it full force.
Yes, timing wise, it just works a lot better. It's just faster. You don't have to worry about technical difficulties, anything else. And then in person, it's easier to listen and understand. It's easier to judge body language, that kind of stuff. So yeah, it seems like the preference is everybody mask up and let's meet, but it is nice to have Zoom as a backup, or, if somebody is particularly susceptible, the technology works. We can do it. Like you said, Ms. Moore, there are, breakout rooms so we can still caucus, other things like that. So Zoom is accommodating enough that, we can have effective mediations virtually, even if it's not the preferred method.
This is Eileen. I'll just mention, one of the questions we ask our registered neutrals is to complete a survey at the end of every year. And this year we asked them what changes they made to their mediation practice as a result of the pandemic. And we wanted to find out what percentage of their mediations are being conducted in person, virtually, by Zoom or some other web-based platform, or by telephone or a hybrid. And surprisingly, 65% of the mediations were conducted in person, with maybe about 18% being conducted by a web-based platform and about 12% by telephone. And then the remainder was just kind of a combination or a hybrid of that. So I thought that was kind of interesting. We do have another question asked. Has anyone ever considered including a mediation clause in the lease prior to the eviction proceeding, or a similar notice to like an arbitration clause? And would the statute allow it? Would the parties get together? That would allow the parties to get together before the relationship is truly broken. Any comments, panelists?
I would say the overwhelming majority of leases no, I would say the answer is no. I don't think that that's a concept that has hit the ground yet. I think that in order to do that with most landlords, you would have to really have a public relations campaign, because I think most landlords are going to be like, I don't know about that. Something else to have to do to get rid of somebody. But maybe with some education on the power of how quickly you can get a situation resolved, that would change. But I would predict that globally there would be resistance to that from landlords until they learn a little bit more about it.
Now, as far as the legality of it, there was a question, would the statute allow that? The Landlord-Tenant Act is 35 9A 101 through 603, something like that. And there shouldn't be anything that would actually, stop a landlord from at least, putting a mediation clause in a contract. And so legally speaking, I don't think it'd be a problem, but yeah, we would have to kind of start getting landlords on board and, send them maybe, sample provisions that they could consider putting in their leases.
But thank you for answering that question. And, when we get down to the mediation itself, how do you set the tone when the parties come together for the mediation?
Well, I guess that would definitely depend on if the parties are represented by counsel or if they are pro se litigants. Normally, if the parties are represented by counsel, of course, you try to get your, lay the framework of where everybody with a positioning statement, if that's something that you do in your practice, you want to make sure of where everybody's coming from, because there may be some things that you can have in mind before you get to the mediation process. So I would say that it just depends on if you are doing pro se litigants, because if you're doing pro se litigants and they've never had any mediation experience or never been in a mediation, you're going to take a little bit more time and try to explain that process so that they understand it clearly, so everybody comes to the table with a true understanding. Normally, if you have a landlord and they have multiple properties, now you do have some landlords that may just have one or two properties that may have never had to evict somebody, and they need to have that those things explained to them as well. So I guess the framework in mediation is just basically getting both sides to some extent with the positioning statement, so that you can come in and you can be as open and clear on where you're starting in the beginning. So that's what I would say as far as laying the framework for the mediation. And of course, explaining what our rules are and get our confidentiality agreements, and understanding that we don't have, we are the neutral. We're here to try to resolve this and make an agreement that you can live with. And one of my pet peeves is, I want an agreement, not that you can live with, but an agreement that you will do. There is nothing like an agreement that people make, and then on the 30th day, oh, I can't make that happen. I can't do that. Or so we want to make agreements that actually have some, ability for these people to make it. Because if you come into something, oh, well, okay, give me 30 days and I have your money, blah, blah, blah. And then when that happens, 30 days come and there's no money, the landlord is not going to, of course, be happy in that particular case. So laying the framework is just making sure everybody understands the process.
In mediation, we talk about rights-based framing and interest-based framing. And, it's very clear, and I think Holly talked about that too. And this panel as well, talking about, well, it all comes down in some respects to money. Money is owed, and that's the right of the landlord to receive the rent that's owed to him. But interest-based framing is another aspect where it takes a look at the interests of the parties and the values. And I think y'all have talked about that and getting to understand each other and how it can be beneficial to both parties. I don't want to talk a lot, really much more on that, but because our time is getting short and there are just so many more things we'd like to hear from you all on. But what tips do you have, panel, for a positive mediation experience for the participants?
I think that one way to really have mediation work is to be a little more artful in letting the participants reach their own conclusion. I think sometimes if you come in there and you've got it all figured out and you just say, well, here's what you got to do, people are more reluctant to accept that. But I think if you carefully, and I'm not saying waste time, but lay the breadcrumbs to where they fill in the blank, that's, to me, is always much more successful than trying to have the answer for somebody.
I think that's one of the beauties of having skilled mediators, because of the experience that you all have. You know how to interact with the parties and help them explore various options. So it doesn't appear, that you're favoring one side or you're pushing one issue or one side over the other. And I think that's one of the beauties of being a mediator, is you are a bridge builder and you help them negotiate. Panelists, any other comments?
Well, I've found that it just helps to get everyone comfortable at the beginning. Whether that's just, hey, here's a soda or water, here's a piece of chocolate, something, calm everybody down, get them ready, go through, the mediation process if they're unfamiliar, very slowly, make sure they understand it. And yeah, once everybody's comfortable, it's a lot easier to have productive back and forth.
Panelists, when you conduct your mediations, do you bring the parties together initially and then go into caucus? How do you normally begin your mediations? Or is it situational?
I think it's situational. I've had mediations where initially it was not in the best interest to bring the parties together. And then I've had mediations where because we were able to get prior information or information prior to that mediation, we knew that they were comfortable with them being in the same room and we could start in the same room. So I think it just depends on the situation. And I think that just depends on your preparation. We definitely want to give the parties the opportunity to craft their own agreement that they can live with. Definitely, with us, with a tad bit of guidance and our knowledge, because I think everybody who is on this panel at this time are attorneys. So sometimes we have to make sure that we are out of that frame of attorney mode and into the frame of mediation mode, because it can easily blur those lines when you start talking in legal matters. So I would just say, for me, just making sure that when we bring them together, that they're comfortable being in the room together.
I think that's something that you need to find out up front. I always default to not bringing them together, because I think for the overwhelming majority of people in this spot, whether it's landlord-tenant or divorce or a civil action, car wreck, whatever, there's a reason that you're going to court or what have you. You can't get along. Now there are the rare situations where people can be in the same room, but I, as a young lawyer, one of the very first mediations I ever attended was a very high dollar case, and they brought us all together at the beginning, and I just won't ever forget it. The defendant, which was a corporate hotel chain, right out of the bat, their lawyer said something absolutely incendiary, and it made what would have been a one-day mediation go into a week. So I won't ever forget that. So I default to not bringing them together, but I do try to ask. And if I haven't had a lawyer before me before, I always explain I normally don't, but do you want me to? What's the temperature?
And Eileen, typically, I think the answer is it depends on my end, but I will tell you typically, that's not something I do. I will keep everybody apart until I can I do a lot of front end work. So I know by the time they get here, I know that's kind of a barometer of how things are in terms of temperament. But, the attorneys I work with too are very, very frank with me, but I will tell you that most of the time, everybody's kept separate. They come and go at different times. Nobody sees each other typically. I will work between them until I feel comfortable. And I can count on both hands probably the number of cases I've ever brought everybody together on. Typically, if we get very close and nail down almost everything, I will have meetings with the attorneys separately. And I explain in detail to their clients that, look, at some point, very early on in the process, at some point, what I may do is I'll speak with your attorney privately out of your presence. If that happens, we're not we're not out scheming. We're just trying to figure, there are a lot of nuances to these cases in terms of legal issues. And what I'm doing is speaking with them, and I may speak with the other attorney. And typically what happens is I have at least one of those meetings in my office and say, okay, look guys, here's where we are. How do we get this finished up? But very, very rarely do I put everybody together. So it's very difficult, as it was just alluded to, very difficult to put that genie back in the bottle if it goes bad. It works until it doesn't. But then if it doesn't, I've got a mess to clean up. Okay. So, hard to unscramble the egg.
I know we're getting short on time. I know we talk about outcomes, and it's arranged. Either the tenant remains in the possession or they vacate the premises. And so one of the beauties of having a trained mediator, an experienced mediator, is they can help the parties explore various options. And on this slide, we've got some various options. Panel, would you like to comment about some options that you've seen or helped landlords or tenants with that you'd like to address?
One little quirk that I'll go ahead and share is don't forget about, we talked a little bit about those resources that tenants have in their own life. That can work both ways, not only to be helpful to the tenant, but it could also be helpful to the landlord. If there's a sheetrock issue or something's wrong, the dog chewed off a door, whatever, perhaps that tenant has someone in their life that is a tradesman that can come in and fix that. So kind of keep those things in the back of your head. What resources does that tenant have to fix some of these odd and end things that are a problem?
I definitely, just to say, I like to make sure, and you can't make sure, but you want to make sure that the tenant, and when whatever mediation comes out of it, whatever comes out of mediation, that people are treated with humanity, because that's the eviction process is a very emotional process. Even, and I know we're not talking about foreclosure in this matter, but foreclosure is a very emotional process, because when you look at eviction, of course, someone is about to be evicted. They may not know where they're going. So I try to make sure the outcome is, of course, like I stated in the beginning, something that everybody can deal with and they can contend with. If I get a tenant that comes in, well, I can just be out in 2 days or 3 days, and you're looking and you're saying there's no way that person's going to be out in 2 or 3 days. You want to make sure that the outcome is something that people can actually do and accomplish. So that's one of the things that I really, really work hard to make sure that we get. There are definitely a lot of ways to be creative. And I know that the panels and the panelists and everybody that's probably a mediator on this particular training section in CLE knows that we want to come up with an agreement that that as a mediator, you are very comfortable with, that all parties are going to have a part in. They crafted it. You've just given, like they said, the breadcrumbs to get there, so that this is something that they can actually do.
Very good points. We talk about power imbalances because it seems like in most cases, the landlord has the cards. How do you mitigate the power imbalance? That kind of ties into why negotiate with a tenant who's not paying rent.
Well, I like to kind of temper the plaintiff, and they want to come in strong, that they have the legal upper hand, blah blah blah. But I want to back them up a little bit, make sure that they did everything right. A lot of times they will have sent a 7-day letter instead of a 7 business day letter, something like that. And you can point out the weaknesses of their case, but also point out that at this point, the tenant doesn't want a whole lot from the landlord. but the landlord wants the rent arrearage. They want the late fees, the attorney fees, the interest, that kind of thing. So the defendant does have a little bit of power as far as negotiating payment plans, that kind of thing.
I think hitting at the lowest common denominator for the landlord balances that power. You're going to sit here and argue over $500 or $600, and the next rental contract that you could possibly have in 3 to 4 weeks is worth 10 or 12,000. That's how you bring that, how you knock it down and say, you know, stop messing around with this and go on to the next person.
I think that's a great point because you're talking about the cost benefit analysis.
Let me also mention right quick, one thing that we have not talked about at all that y'all need to be aware of. You know, we are having more and more and more condominium complexes built throughout the state, not just in the Gulf Shores area. They're up in Florence, they're all over the place. Those present special issues because the tenant stands in the place of the owner while they are under lease and in possession. And condominium associations are like tiny towns, little cities. They can fine for rule violations and misconduct. Those fines are collectible as a mortgage. So a landlord can really get in a sling with an unruly tenant and run the risk of losing his own property to the condo association. So knowing if that is a situation that you're dealing with, it makes it even more important for the landlord to get the person gone if they can't abide by the association's rules. So that's another little quirk that you might want to watch for.
I think that's an excellent point to bring up. Panelists, we are getting close on time, and so I would like to give you an opportunity for any final comments you'd like to share with our attendees.
I think your slide says it best. Understand the landlord-tenant laws. Make sure that if you are representing a landlord, that they comply with those if you're going to try to do anything, or try to litigate to get somebody evicted. But the issue that I wanted to say is always, if you have a case that you think after you look at it as an attorney, that would be best in mediation versus litigation, reach out to a mediator, someone maybe in your area, maybe not in your area. We do a lot of pro bono work, as Aline said earlier, and I've done it before, I've assisted. So it may be that it can save time and money to your client, especially with those who have major apartment complexes with numbers and numbers of apartments, and you want to get the person in and out so you can get it re-rented. In addition to those who may have clients that are just now getting into the rental business, that decided, hey, I want to rent my property. If you have a client like that, you may want to sit down and make sure that they know about mediation, that they mention that. So I just want to share that we are out here to assist. And if you call, Lean said it better, this is a friendly environment. So just put the call out and see if we can assist you.
And attendees, I put on this slide some additional resources. You can Google them, the links there. You'll be getting a copy of the PowerPoint slides sent to you after the presentation. But if you're interested in landlord-tenant mediation and some thoughts, here are some additional articles that you might want to take advantage of in reading. Here's how to contact our presenters. And wrapping up, I do want to thank all our panelists for giving their time and sharing their wisdom and insights today. This has been really a terrific program. I appreciate everyone for your patience for our few technical glitches. But thank you, Holly, Brian, Jamaria, Garrett, and Brian. Wonderful insights. I also want to thank the Volunteer Lawyers Birmingham, Legal Services Alabama, the Dispute Resolution section of the bar, along with the Center for helping to co-sponsor this free 2-hour CLE. There is an evaluation. It's through surveymonkey.com. You can copy and paste this into your web browser. Item, we will also send it out by a separate email. So we very much value your feedback. Please tell us what you'd like about the program, what other areas that you would be interested in learning. We're very much into trying to help attorneys and mediators improve their skills and understanding of alternative dispute resolution. So please let us know how we can help you. There is a code that you will need to enter into the evaluation. It's ACDR 2021, and there will be a place for that on your evaluation. We're going to ask you to complete the evaluation by May 7th, which will be next Friday. And again, we'll be sending you the link if you're not able to copy and paste the link right now. I would invite you to visit the Alabama Center for Dispute Resolution's website and our Facebook page. We do post our free training events. We are working on a collaborative law practice series. Our next series is on May 13th. We are also working on putting on a foreclosure mediation training for mediators coming up. And if you're you've heard of mediation, but you didn't take a class in law school, but maybe you'd like to learn a bit more about that, let me know. We're looking at maybe putting together a 1-hour introduction to mediation on the basics. And again, I want to thank everyone for your time and joining us today. If you bear with me for just a minute, I'll put this link in the chat box so that you can copy and paste or maybe go ahead and complete the evaluation. But again, my hat's off to a superb panel, great information, and thank you again for this timely presentation. Does anyone have any other questions or comments? We've got some things in the chat box, a lot of thank yous, and hats off to our panelists. Wonderful job.